why their fishing boats, fishing nets are not just confiscated but banned. No hope that they'll ever be returned to them. How are they going to survive? And you can imagine one fishing boat normally supports about 8-10 people within the area.
This is Beyond Crude, a podcast dedicated to the Stop EACOP campaign that effectively has unleashed quite a significant impact on human lives from Lake Albert in Uganda all the way to Tanga in Tanzania. And joining me to discuss to have this conversation today will be four guests. We do have Ariampa and Sam from Kampala, Uganda.
Good morning. I am very happy to be here.
And we do have Zaki all the way from Joburg.
Good morning, Darius, and thank you for having me. Happy to be here. My name is Zaki Mamdu, and I am the coordinator of the Stop EACOP campaign.
Thank you. And we do have Mark all the way from Lamu in Kenya.
Good morning, Darius. I'm happy to be part of this conversation. My name is Mark Odaga, and I'm a human rights and environmental lawyer from Kenya. Thanks.
Thank you, gents, for joining us for this conversation. And this being episode 2, our critical focus on the EACOP would be on the human rights aspect of it. And just starting out this conversation, coming to you, Zaki. It's been literally close to a decade, if not a little over a decade. From your experience, how effective has the global advocacy been in pressuring governments and corporations involved in this EACOP campaign in terms of the gains and the traction so far? What's your assessment?
Look, the campaign has been really quite successful over the last few years. Many of the partners have been working on this for many years since the project itself began to take shape. And later in 2021, a formal coalition was established to confront the construction of the East African crude oil pipeline, to really bring to the fore the harm and damage that this project has already caused and continues to cause and will cause if it is ever in a position where it reaches financial close and is finished. And over the last few years, the campaign has been really successful in blocking the flow of finance into the project itself. And that's really been its main strong point. And it is why, to date, the pipeline itself has not been built because it has not been able to realize financial close. What we have managed to do through, building a strong grassroots movement that is rooted in the experiences and the aspirations of communities on the ground, but which is also recognize the absolute importance of international solidarity in a fight such as this, a fight against a project which really in many ways stands to impact every single person on the planet because of its implications for the climate broadly, but of course more locally and regionally a project which would have direct and irreversible impacts on the environment and local economy in the project's host countries and in surrounding countries. And so through the targeting of major commercial banks and various insurance actors and those who we know, tend to support destructive and harmful projects like this, over the last few years, we've managed to get a total of 27 major banks to make public commitments that they will not get involved with the East African crude oil pipeline project, as well as 28 insurance actors. In fact, just at the beginning of this year, additional 5 major insurance actors came out to say that they will not support this project because they recognize the extent of the damage, destruction, and harm that this project will cause, but also the kind of violence, both symbolic and physical, that is already surrounding the development of the project, the land acquisition process, and of course the oil drilling activities themselves as well. So I would say that the campaign has been quite successful in delaying the project to this point, and we'll continue to build this movement and exert pressure where it needs to be exerted to make sure that financial and insurance actors are fully aware of the dangers and harms surrounding the project. This is something that is not necessarily obvious for a lot of people. And we know and we have seen how companies, but also governments, take shortcuts in their environmental impact assessments and the social impact assessments. And these, documents and these assessments are used to inform the decisions that financiers and insurers make. But we know that these documents are often inadequate and don't fully capture the harm and the damage that would or already has been caused. And so what we have done working closely with communities and local civil society organizations on the ground within the project host countries is make sure that we capture the qualitative lived experiences of communities who are on the front lines to this project, but also make sure that we properly understand and capture the ways in which a project like this would stand to impact important wetlands, including Ramsar site, important water sources and agricultural lands, and really the natural resources that thousands of people depend on for livelihood and sustenance. And once we capture the harm that it has caused, we've been able to use that to really engage financial insurance actors who have been willing, and many have been willing, to come to the table and to say, well, look, there's no way that they can get involved with a project that is this harmful. And this damaging, especially at a time where the world urgently needs to transition to renewable energy sources, but also at a time where the world urgently needs to address underlying social issues of inequality, hunger, of homelessness, poverty, etc. So we are glad that many have come to the table and have made these public commitments that they will not get involved with this project.
And I mean, thank you for that outline. And just coming to you, Wakili Odaga, I mean, given the complexities of climate litigation, and I mean, it's climate change and climate adaptation conversations going on all over, but then specifically on litigating these kinds of, climate issues, have you seen cases where communities effectively, used legal means to stop, such harmful projects as EACOP? What are some of the biggest challenges they face when they try to pursue this litigation?
Thank you for that question, Darius. I think increasingly the impacts of climate change are becoming hard to ignore and avoid. And from a legal point of view, I think one would say we're past the point where many people question whether these climate change impacts are real. Most of the litigation now turns on questions of attribution. So the difficult questions around whether you can attribute blame for a specific impact on a specific corporation, organization, and even bigger questions around what some of the obligations of countries are in terms of the impacts of climate change on local and indigenous communities. You could say that there has been an explosion of climate litigation cases, particularly after the Paris Agreement in 2015, globally and including in Africa. And there are a number of cases that have been community-led. So perhaps I can just highlight two and maybe just make a few points in terms of challenges and lessons from these cases. So the first one, I think, and the more recent one, is a 2022 case that was filed by community groups and organizations in South Africa to challenge the government's decision to issue exploration rights to Shell and a company called Impact Africa to start exploring for oil and gas off the coast of South Africa. And one of the first activities that they would undertake were seismic studies or surveys. And this involves sort of releasing high level sort of bursts of using this technology that they would use to blast sort of low frequency sound to the seabed to sort of detect where the deposits of oil and gas. And this has a lot of impact, obviously, for the sensitive marine ecosystems. And so these groups brought a challenge. And they raised a number of issues. First was the lack of consultation of the local communities, including small-scale fishers who would stand to be impacted by these activities. The second is the failure to account for the impact of the negative impacts of these seismic surveys on the livelihoods of these small-scale fishers and communities, on their cultural and spiritual rights. And they also raised the issue of climate change because, of course, when this exploration is happening, it's with an eye towards extracting and ultimately burning these fossil fuels with increased greenhouse gas emission implications. The other case that is much closer to home, actually, is a case filed by Save Lamu and local communities here in Lamu, where I currently am. And this involved a challenge to the decision to issue an environmental license for a coal-fired power plant in Lamu, which is the Old Town is a UNESCO World Heritage Site. Lamu is also home to a UNESCO Biosphere Reserve. it's a perfect example of how local and indigenous communities have lived sustainably and in harmony with nature for centuries. And of course, while development initiatives are needed, I think where they threaten to destabilize that balance and heap the costs on local communities, then it's always going to be a problem. And so the communities here filed a challenge to the decision to issue that license. And similar arguments again were raised, one around the lack of consultation in terms of why this coal-fired power plant had to be set up here. Some of the features of this coal-fired power plant, for example, where the coal ash was to be stored was to be set up in places which are prone traditionally to flooding, and just generally no consideration, proper consideration was given to some of the impacts it would have for the marine life and local communities here. Thinking, for example, about the air quality impacts, for example. It's a testament to the resilience and sort of commitment of these communities that both these cases were successful. And so it is possible. Two lessons that I think are worth drawing from these. One is a systemic challenge, and I think Zaki has alluded to it. It's the fact that the impact assessments that are carried out as a precondition for these projects often carry out consultations with local communities as a formality. It's a checkbox exercise. And several courts have castigated these project proponents for going about these processes in that way, so that then communities often aren't given adequate information, which in itself is a violation of their right. But secondly, it also forms part of the challenge because it becomes extremely difficult to challenge a project when you don't know the full scope of it. It's particularly problematic in instances where communities are not aware that permission has been given for some of these projects to occur. And that usually has a direct implication if you want to challenge this in court, because there are usually very tight time limits. So in Kenya, for example, if you're going to challenge an environmental impact assessment license, you have to do that within a 60-day window. It becomes very difficult if you're not involved and given proactive disclosure of information to meet those requirements. So that's one challenge, but I think it's also a systemic issue that crops up. The second is in terms of climate change and climate impact assessments. So as I mentioned, I think we're at a stage where very few people would deny that we are facing adverse climate impacts, and a lot of it has to do with human causes, predominantly the burning and use of fossil fuels. What has yet to take off since the signing of the Paris Agreement is sort of an incorporation of climate impact assessments at a national level, so that when government companies are making decisions in terms of projects to pursue, then there is a full consideration on how these projects either strengthen, weaken the resilience of communities, but also add to or aid in the adaptation to climate impact. And again, it's a feature that recurs through some of these cases. Now, it's often not as difficult to show that these considerations haven't been taken into account. The other challenge is, the real challenge sometimes is in terms of marshalling the expert evidence. So in terms of calling expert witnesses who would be able to help prove these cases. These experts can be quite expensive. Some will give of their time freely. Most will require remuneration. Sometimes they might be willing to give of their time freely, but you would still need to foot the cost of their travel and accommodation, especially where you're dealing with international experts. So this can be hugely prohibitive. So I think that's a huge challenge. The second and related challenge is in terms of a lot of these huge projects often are being undertaken in partnership by the governments and states, and mostly large multinationals, as is the case with EACOP. So it means that they often enjoy a lot of state support. And so filing a case in court means that you're not just facing hurdles legally, but also politically. That can be quite a challenge. The last point, and then I'll stop here, is in terms of the approach that communities have taken. It's required a coalition of effort between local communities, learning and exchanging information between themselves and with each other in terms of how to mobilize, how to identify experts, and also standing in solidarity in terms of mounting pressure when government, state, corporations are willing to hear the concerns they're trying to raise, and then joining forces not just locally, nationally, with civil society organizations, and crucially internationally, because I think climate change is an issue that cuts across, right, from the local to the international. And it's that type of coalition that has proven to be very effective in both cases, but particularly so with the example of the coal-fired power plant in Kenya, because I think a huge part of that victory can be traced to the success of the campaign that grew out of it. That's the Decolonize movement and campaign, which brought together several different actors in order to push back. So there are lots of lessons and a lot has been written and said about it. I think it's a matter of each fight with its different peculiarities and trying to connect local communities so that there's learning exchange between them to be able to continue not just the litigation efforts, but to push back against some of these harmful projects.
Okay, thank you for that. And the freedom of expressions, especially the limitations and the potential misuse of courts by the state and the other actors to try and silence dissent against this case of EACOP. You can pick up from there, Ariampa.
Thank you, Ab, for your questions. My name is Ariampa Brighton. I am a lawyer representing the students who have been arrested for expressing their views regarding to the oil developments, including EACOP and other 3 oil projects. And I also work with a small group of university students that have been working with to create massive awareness of the impacts of EACOP and other oil projects in Uganda. I will start with the laws that can answer that question. One is the civic rights and activities of Ugandans that are provided within our laws, specifically Article 38 of the Constitution of Uganda, which is a big line, whoever can access it. It gives the right every Ugandan to participate in peaceful activities, to influence the policies of government through civil organizations. And now, this law, I want to relate it to Article 29 of the Constitution that protects whoever engages in such civic rights. That is protection of freedom of expression, movement, assembly, and association. And now goes the point of people that have been trying to, express their views, their opinions in the development of the East African crude oil pipeline and other oil projects in Uganda. Yeah, so we have both issues that are the issues of absenteeism, adjournments, and now like to be on substantial things that is also causing limitations on the rights of, especially when they want to seek court remedies, especially on bail, and then the who has imprisonment, like I mentioned. So all these have been limitations on the expression of freedom of people who are trying to speak for communities, who are trying to defend their environment rights, who are trying to defend wildlife that are not basically speak for themselves.
Okay. Thank you for that. Just coming to you, Samuel, I think, again, you can start with the introduction, your names, where you're joining us from, and your role within the Stop EACOP campaign, and then we'll get the question. Samuel?
Yes, thank you very much. My name is Samuel Okulony. I work with the Environment Governance Institute, an NGO in Uganda that works with the frontline communities to try to raise awareness of the impact of EACOP and to engage the insurers and the financial institutions to stop funding the climate bomb that is about to burn the planet, as well as displace thousands of communities from their land.
Okay, and I mean, just speaking into that, what is your take on the recent ruling around land acquisition, the unfair compensation practices, which has happened both in Uganda and in Tanzania, and also particularly, and it's something both Odaga and Zaki have touched on?
Just to start on that question, one, I'll state that land is a single most important asset that supports thousands of rural communities in Uganda. And the compulsory land acquisition currently ongoing, specifically for the development of EACOP and other upstream projects, are happening in rural areas in Uganda. And this directly impacts thousands of people, especially in regards to how they live and how they generate income to support their families. And you'll find that the Ugandan laws are clear in regards to how land can be compulsory acquired for any development in the country, be it oil and gas activities, be it minerals, be it safety or health-related matters as prescribed under Article 26 of the Ugandan Constitution. It dictates that specifically the land must be acquired. The state has a right to acquire this land. However, this can only be done after payment of prompt, fair, and adequate compensation for the local or affected communities. However, the companies, or specifically oil companies, and the Ministry of Energy and Mineral Development have gravely violated this provision and used it at the expense of the local communities. From the time the land acquisition was started, many communities have experienced delayed compensation, poor evaluation of their land and property, and others up to date from 2018 when their land was assessed have not yet received any compensation and living in uncertainty as to when they will be able to get compensation or they'll be relocated from the land that have been earmarked for oil developments. And the judiciary, one that we hold so much regard and trust to a lot in regards to these developments, and that would act in neutrality to give hope to each and every landowner in Uganda. On December 4th, the Ministry of Energy and Mineral Development filed a case at Hoima High Court challenging the 42 families in Bulisa that challenged the poor compensation, poor evaluation of their property that was being acquired, affecting over 16 villages, amounting to about 59 acres of land. They simply challenged that the land that they are taking and the value of money that they're giving to them is not equivalent. One, they generate a lot of revenue from this land. All their lives depend on it for their survival. However, a meager amount of money was being given to them that was not able to help them even replace the land that was being taken. They simply said, we need to renegotiate and give us a fair value for our land. But in a turn of events, in unprecedented turn of events, we saw that the case that was filed on December 4th, 4 days later, the High Court delivered a bomb ruling that gave the Ministry of Energy and the oil companies the right to evict communities from their land. And this ruling was delivered in front of children that had escorted their parents to the courtrooms, the women that had hope in the justice system, seeing how justice was served unfairly on them and their husbands inside the courtroom. We need the courts to act impartially, to be able to deliver justice. And they should not be used to deliver injustice. One thing that for sure is that we need speedy trials, especially related to land matters. But what kind of speedy trial do we need here? The people need to be duly served. They need to be aware of the ongoing court processes. They need to be able to get legal representation. However, the people that were in court for this, some of them did not even know that the case had been filed against them. So meaning the court eviction orders were delivered in the absence, and you find that the money, small money, that was not adequate for them to replace the lost land was basically going to be deposited in court, and eviction orders were delivered. And this has a lot of implications. One, in 2014, when I was working at my former workplace, specifically in March 2014, we filed a case in the High Court of Kampala, specifically challenging the compulsory land acquisition and violations therein under the compulsory land acquisition for the oil refinery in Hoima. However, up to date, 10 years down the road, this court is still pending. Every time they're about to make a decision, either they change the judge, and a new judge will come technically saying, I need to study the case, start afresh with cross-examination of witnesses. And when they're about to make judgment or deliver judgment, they again go back and get a new judge, or the judge is not available, and playing with the court system to deliver injustice against communities that only have hope in ensuring that they're able to protect their land, to generate a livelihood, to provide for their families, provide for their children. And this has great implications in regards to how the whole sector is happening. This judgment came in specifically looking into the compulsory depriving communities of their land. The children are watching on how this was happening. Currently, the men and women might pass on with time. The children are looking, growing up, and seeing how their parents have been deprived of this land at the expense of carbon bombs that have no future in our land, and they will rise up against these projects. We need to see to it that the companies and the oil companies need to vacate and provide room for energy transition, which is happening globally, which has come at the right time that we can be able to channel our path to sustainable growth for Uganda.
Thank you, Samuel. Coming to you, Zaki, we're clearly dealing with systemic violations here that take all kinds of forms. And I mean, in particular, when you're looking at EACOP, besides Total Energies, do the other players involved in these have a history of human rights violations, both in this project, but in any others that you've looked into over the years?
Thanks, Darius. They absolutely do. And I think both Brighton as well as Sam have spoken to, some of the issues, but also have spoken to some of the perpetrators of these kinds of violence that are unjustly enacted onto land, human rights, and environmental defenders, but also just ordinary people in communities that, are on the front lines of these projects, as it were. I don't think the kind of violence that we see in EACOP is necessarily unique to the EACOP project. I think it is, though, very much a characteristic of the entire fossil fuel industry and the proponents of that industry. We see this across the continent itself. We see it with gas projects in Mozambique, the oil projects in Nigeria. We see it with mining in South Africa and Madagascar. We see it with mining in Zimbabwe and in Botswana. Across the continent, this ongoing exploitation and extraction and destruction of communities, the hands of multinational corporations and a multinational elite, as well as national elites within these various contexts and countries, who really operate in order to extract the most surplus. These violations are numerous and quite severe. We see, has been made quite clear, that we do know that Total is the root of many of these violations. In fact, there was a Global Witness report that came out toward the end of last year, which directly implicated Total in the harassment and intimidation of communities, which left communities feeling coerced and forced to sign over their lands, as Sam has spoken to it, at really rates of compensation which are inadequate and unfair. Communities signing over their lands and to date not having received compensation, all these things. But what this report found is that there were officials from the company, from Total, who were there and who were either party to this intimidation and bullying or sat by and observed. So at the very least, Total has not done enough, if anything, to ensure that the rights of communities are upheld and protected. And the report has, in fact, even gone further and has found evidence that, as Comrade Brighton spoke to, the kind of arrests and detentions of environmental, land and human rights defenders and of activists is a common occurrence within the Ugandan context, specifically within the Tanzanian context as well, by the way. But what this report has found is that in some instances, directly prior and suspiciously prior to the acts of repression against activists and to the detentions and arrests of those activists, Total has been in communication directly with Ugandan authorities. And now it's of course difficult to get clear evidence and information which would tell us exactly the nature of that communication. But we do know through experience and through the experiences of the communities, not only in Uganda and in the EACOP host countries, but across our continent. We know through those experiences the ways in which these multinational corporations operate. We know the ways in which they promote, fund, and directly party to repression and violence against land and human rights defenders. And so we are not surprised, and I think it is fair for us to assume and to make judgments around the nature of those communications between Total and the Ugandan authorities, which happened suspiciously prior to the arrests and intimidations and detentions of activists who opposed the pipeline. Look, beyond Total, of course, there is the repression carried out by state authorities and state officials. I think that is an immense issue where you do have, and this has happened throughout the land acquisition process, where you have soldiers and other military officials or police officials also involved in the bullying and intimidation of communities. In some cases, telling communities, well, you have to sign this or otherwise we'll move you anyways and you'll get nothing. So there's no room for them to oppose or even negotiate the value of that land. And of course, many instances of community members being left out entirely, especially if I can just add this as a side note, especially women. What you find in many of the project-affected communities surrounding EACOP and those which have been subject to this compulsory land acquisition process is that they've identified single individuals in the households, who, in their view, qualify for compensation. Never mind the rates and all of that. But what they have not understand, and it's a complete inappropriate, cultural misreading of the context of these communities, where, a single compensated, of course, very poorly so, but the other family members and members of that family body, which in many ways, look, it's often women who cultivate the land. And in that way, it's often women who give value to the land, yet do not qualify, are not recognized by the company nor the government as qualifying for compensation. So are excluded entirely and are left absolutely stranded, unable to put food on the table, unable to continue sending their kids to school, unable to access quality healthcare and all of these things. Now, if I can just speak to a recent occurrence as well, on the 16th of January this year, 2024, there was an instance in the Kingfisher region around Lake Albert where the oil drilling that is operated and owned by CNOOC, the Chinese National Offshore Oil Corporation, has begun, and where they've begun drilling into the bed of Lake Albert and extracting oil. Of course, not operating at full capacity, because without the pipeline, they cannot pump that oil into anything and take out as much as they would like. But there are numerous fisher communities of fisher folk who have existed and who have lived and drawn their sustenance and their livelihood from the Lake Albert water source for as long as you could imagine. And those communities, of course, have been pushed aside in order to make way for the oil operations there. But also recently, on the 16th of January, there were a number of fishermen who had their boats seized by the UPDF, the Ugandan military, and by these soldiers who took 15 boats from these fishermen and burnt them along with numerous other important equipment such as nets and fishing gear and all of these things that they really need to eke out their living from that water source. And those boats were burnt, their equipment was destroyed. In other instances, fisher folk have had their boats confiscated and seized without the authorities giving them any reason for it. And obviously, it seems as though these fishermen are deemed to have been too close in proximity to the oil operations there. But it is those oil operations which are encroaching on their fishing waters that they have operated for years and years and years. In fact, we should understand it. Morally, we should look at it and understand it to be the other way around, where it is the oil operations which are far too close to the fisher communities and to their livelihoods and are encroaching on their livelihoods and their waters. And shortly after that instance, during January, there were 19 fishermen who were also arrested arbitrarily and held in detention for periods of time which can be deemed unlawful over the 48-hour period which you can reasonably keep someone. Never mind that the arrests themselves seem to have been entirely and completely unjust. And this is something, while it is the Ugandan military that is directly involved and responsible for these violations, that entire Kingfisher area, if you try and go there, even if you are a civil society actor and you are going there to monitor and to observe what is going on, it is almost guaranteed that you will be harassed by soldiers, but also by project officials who, of course, communicate and work very directly with those soldiers who have been deployed there to protect the oil interests of the Chinese National Offshore Oil Corporation. And so it is not just Total, it is the entirety of the fossil fuel industry that is responsible for violence and is responsible for the destruction of communities and livelihood. Of course, it is also repressive state actors and those who answer to these national elites who have their own interests in these sorts of oil operations. I think that the same can reasonably be said for Tanzania, where civil society actors who visit with project-affected communities and engage with them and, make sure that they are making an attempt to understand their experiences. Even there in Tanzania as well, those civil society actors are often arrested, detained, threatened, and intimidated, while organizations, tend to have their licenses revoked and all manner of other threats to their finances, and which really threaten their ability to be able to operate effectively.
Uh-huh. Yeah, thank you, Zaki, for that. Coming to your Daga, just briefly, based on your experience with the East African courts, this is a pipeline literally planned to cut through, two East African countries. So based on your experience with this court in terms of judicial precedents, but also the experiences in there, do you think, in your assessment, that this court will be able to play a fair arbiter for the communities involved in this large-scale project?
I think think there's quite some reason to be concerned when we look at the case challenging the construction of the East African crude oil pipeline. This case was filed in November 2020. And one of the reasons that necessitated filing it in the sub-regional court was something that I think Sam has alluded to, which is the lack of independence or sort of speed shown by courts in Uganda to progress cases that are brought on by communities challenging some of these projects that enjoy quite a lot of political support. The hope is that regional courts, being a little removed from these sort of the local politics and the power that the executive sometimes wields against the judiciary, are in a much stronger place to then act independently. That is the entire function of setting up these regional courts and sub-regional courts. They are meant to actually hold the states accountable where they violate rights and to also give directions in terms of the obligations of these states for those violations. And we've seen a number of cases where they've done that quite effectively. When we think about the regional court, that is the African Commission on Human and People's Rights and the African Court of Human and People's Rights, there have been groundbreaking decisions. The case of SERC versus Nigeria is an important one that I think set huge standards in terms of environmental law and environmental activism. And in that case, they were able to find that the Nigerian government had failed in terms of protecting the rights of the Ogoni people in the face of the exploitative, extractive, and hugely damaging effect of Shell's activities in the Niger Delta. Closer home in Kenya, we've seen the African Commission speak very loudly in terms of the rights of the EACOP community, who have been fighting this battle for recognition and respect for their right to the Mau Forest, now going on 3 decades. Closer home at the East African Court of Justice as well, there was a really positive decision where the court stopped the construction of a bitumen standard road that was meant to cross through the Serengeti, and it would have had huge environmental impacts for the sensitive ecosystem, which is shared between countries. So there's potential for these courts to do well. But I think, as I think the previous speakers have alluded to, what is particularly challenging here is the immense power and influence wielded by the fossil fuel industry and the manner in which they operate and the manner in which they can sometimes co-opt governments and sadly regional and especially sub-regional courts also depend hugely on state support. And so what I would say is every person, local communities enjoy a right of access to justice. And so it's worth pursuing and fighting these cases using whatever means are necessary, including through the courts. It's encouraging to see that despite unfavorable decisions, even in this case, that the parties involved have chosen to appeal. And justice sometimes is slow, but it sometimes is served even if it's late. So, for example, the Maasai community who were affected in Loliondo were disappointed because the case was dismissed at first instance, but on appeal. That case has gotten a fresh lease of life now that the court has determined that it should be heard on its merits. So it's a mixed bag. I think we have lots to be proud of on the African continent in terms of regional courts stepping up. What I think is required is to support these cases, to highlight and I think to speak openly and vocally where there's a sense that the courts are not moving as quickly as they should, where they seem to be hesitating to hear these cases on the merits and dismissing them on very flimsy and light technicalities. And of course, the most important issue is something that I think Sam alluded to, which is with these types of cases, especially environmental cases where the harm is quite often irreversible. It's devastating because it directly affects communities' lands, their livelihoods, their health, that there's also a sense of urgency in determining these cases and prioritizing them so that they are heard expeditiously, and where there's needs to stop and halt a project so that there can be further inquiry into some of the protective measures required, and that's also done. And quite a few of our regional mechanisms already have these built in. There's strong precedent that shows that it's something that the courts can do. They just need courage to do it. I think the final point I'll make in terms of the role of regional courts is something that has been seen internationally in the last 2 years. There are, I think, at least 3 processes that are currently in different courts. There's the Inter-American Court on Human Rights, there's the International Court of Justice, the International Tribunal on the Law of the Sea. All of these courts have had requests to issue what are called advisory opinions on the roles and responsibility of states on the human rights impacts of climate change. And that just shows that increasingly there is a recognition that states have a role, and local communities, civil society organizations are increasingly looking to regional courts to help flesh out some of these obligations so that then local activists, local organizations can use those findings to add to their advocacy efforts. There have been efforts and discussions around similar processes before at the African Regional Court. And so I think that those are also welcome efforts and initiatives, because hopefully they help provide some guidance and standards, not just from the perspective of a single case and a single precedent, but it would be good to hear from our regional and sub-regional courts in terms of some of the cross-cutting standards which could be applied across different states in relation to what the roles and responsibilities of African governments are in the face of the climate crisis, and the responsibilities they have for vulnerable communities who are particularly impacted by some of these development projects.
Thank you, Wakili Odaga, for that. Coming to you, Brighton, the victims of this project are mostly locals. The project itself is regional, but some of the partners and interested players are international. So from your perspective, how can international advocacy efforts help to support and protect the vulnerable, in this case, mostly the activists, and by extension, as Zaki had mentioned, the women and the children involved?
Thank you very much for that question. One is that for over time, the international community has played a great role in influencing the government to cause change in as far as human rights and human rights protection is concerned. And it looks like the government doesn't listen to the voices of the government, but most of the time it listens to the government partners and the international community. I can give you for example, we had issues in the civil space in 2021 where an organization in EACOP had its staff arrested and imprisoned, and it was the international community that the voices that came and the pressure that government released them. So in so doing is that one. We have to see how we can reach out to the national community to keep on influencing the government, and then for the people, for the communities, is that now groups that work on these cases, that work on that speak on behalf of these communities, I think they need to be supported, because you realize that most of the time these arrests happen. Usually, it's hard for these folks to afford legal fees, and this has been done by the international community. We have organizations that come in to help with the legal fees, and they also take care of these people that are facing reprisals. And but I think the fundamental change should start from home. Because we are looking at the far-reaching impact of people that are facing reprisals. Because when you look at every time we have arrests, it is a clear indication, a clear government effort to silence the voices of human rights defenders and society groups that are trying to hold the government and corporations accountable for the human rights violations in the country. So for me, in addition to what the international community can offer, I think the fundamental change should again start with pressuring our government to do specific things, and that pressure can come from the international community, because we have a legal system that should play a vital role. Yet when we have these cases brought before it also plays a party to the limitation of these freedoms. So I think that the international community, one, they can influence the government of Uganda to have a judiciary that can exercise judicial power. Usually, we need judicial officers who should appreciate that judicial power is derived from the people and it should be exercised in the name of the people and compliant with the law. So, because we have like seven cases of such a matter, and we have 3 that have been dismissed because the government, the state has failed to abuse evidence. And for me, these are the precedents that should be followed in the adjudication of other similar cases of arrests. And then we need the international community to also play part to move the government to make sure that we have independent systems. One, you're looking at the independence of the judiciary, because at the time, like some nations, we have a judge who gives a decision against for the people who are affected by legal projects, and that decision has an far-reaching impact on their lives. You're looking at their economic rights, you're looking at their rights to land and what land means to a Ghana. But then you have a judge who's ignoring all the principles of natural justice, all the rules of natural justice, to give a decision against people, and that decision includes eviction of such people. So that's one of the influences of the national community that should appreciate the international practices and try to see how they can influence the independence of this kind of institutions that work for the betterment of the Ghanaians. And maybe the last thing is that we have international practices, our laws, and then Uganda is also part to. And again, looking at the power of the international community that we can do, we should have common laws, especially that protect the human rights defenders, so that they can be applicable in courts. Because even in courts we can use international treaties, we can use any of those international practices as long as the country is a part of those international communities. And I think we need one on human rights defenders, because in Uganda we have failed to enact a specific law that protects human rights defenders, activists. We have failed because we had one that was introduced in Parliament in 2020, the Human Rights Defenders Bill that has not been enacted. But we see all these problems against human rights defenders happen on a global scale. So if we can work as the international community to have a law on human rights defenders, probably in that law they could have provisions where the multinational corporations issue statements when such arrests happen that are affecting the projects they're investing in, because we've had these interests and total keeps quiet, no keeps quiet. So that is a problem. But I think if we have a law in place that can enforce these international companies to issue statements, I think it will play a vital role in as far as bringing our institutions that are supposed to be fighting against such injustice in place. And then maybe the last point that the national community can do, we've seen coming into some political issues when the crisis happen. And one, in Uganda, we have laws, the Human Enforcement Act, that where you can bring an action against police officers individually that carry out these arrests that have been pronounced by courts to be illegal through dismissal of such cases. I think it's a kind of support they can offer to people that are facing the reprisals, or even the society groups to file illegal action against the police carrying out these arrests. I think it's one way that the international community can play a big role.
Samuel Kolong, coming to you and just building up on that, the mid-January incidences that I think Zaki mentioned about the banning of boats and the arrest of the fishermen. Is there a particular plan to carry out concrete steps from the side of the interested parties against these basically violations of human rights against those fisherfolk?
Yeah, thank you very much. I think the incident that happened in mid-January, which has been actually the occurrence of many other incidents that go unreported because of the blockage of access to the areas that Sinop operates, specifically within the Bohoa and Kingfisher. Incidents that do not have rare place in our society. It's very unfortunate that there's this kind of investment that is not prioritized the local or project affected persons, that does not recognize how these people have been living since time immemorial. They have been fishermen all through their lives. And we've tried to engage with different actors, especially in ensuring that we bring this to the limelight and ensure that they are able to respect at least the Aboriginal people that heavily depend on these ecosystems. Lake Albert is probably one of the biggest fishing lakes in Uganda, supporting millions of people within the region, but this has been negatively impacted. I believe that these injustices have been occurring and enough is enough. We need to act. One, we need to raise this at national and international level. I know quite a number of investors, specifically those of Total, of CNOOC, need to be on the right side of history. Can they put pressure on CNOOC to stop this heavy military deployment within the installation areas, which actually they are bringing it, like you rightfully put, bringing these investments on people who have been staying in these areas, forcing to stop the activities that they have been doing without an alternative on how they're going to support their families. Secondly, we have many international bodies that act on protecting the rights of people that are deprived by investments. I know the IFC performance standards always issue guidelines. The World Bank issues guidelines on how these investments need to follow the guidelines, respect the cultural rights of the people. And this is the time that we need them to show leadership, issue statements calling on these companies to stop this extra military deployment, prohibiting people from accessing basic rights. At least these people are not going in to extract billions, but they're looking at a basic right to feed their families. At least we need to respect that. They are working towards feeding their families, feeding their children, are able to get some basic income to get decent quality health care, take their children to school, but they are not able to do this all now. Why? Their fishing boats, fishing nets are not just confiscated, but banned. No hope that they'll ever be returned to them. How are they going to survive? And you can imagine one fishing boat normally supports about 8-10 people within the area. So if you ban one fishing boat, it's not just one person that you're punishing a bigger chunk of people within the area. We need these international bodies to rise and speak up. The investors need to really channel their money in areas that would support areas that would support the local communities. Fishing is one of those with the big potential in the region that they need to prioritize, support the local community to be able to amplify the fishing and generate sustainable income that will support them beyond oil and gas activities that do not have a future.
Zaki Mamdo in Joburg, Marco Daga in Lamu, Kenya, Brighton Ariampa and Samuel Okulong in Kampala, Uganda. Thank you for joining us on Beyond the Crude, gentlemen. You can catch this conversation on Spotify, SoundCloud, and follow us on social media at Stop EACOP.